Hello viewers, in our previous lecture we have briefly discussed what does intellectual property right means. Today I will try to correlate intellectual property rights and information technologies. People talk a lot in the information technology business about intellectual property rights, but what are they? How do they apply to the software technology? Why should you protect them? How do you protect them? Intellectual property rights are at the foundation of the software industry. The term refers to a range of intangible rights of ownership in an asset such as a software program. Each intellectual property right is itself an asset, a slice of overall ownership pie. The law provides different methods for protecting these rights of the ownership based on their type. There are essentially four types of the intellectual property rights relevant to software, patent, copyrights, trade secrets and trademarks. Each affords a different type of legal protection. Patents, copyrights and trade secrets can be used to protect the technology itself. Trademarks do not protect technology, but the names or the symbols used to distinguish a product in the marketplace. The application of the information technology has been expanded and extended to every society in the world. It has a strong connection and association with many areas such as business, engineering, science, healthcare, arts and public administration. Particularly, students from all ages are exposed to the internet and to online information at different levels from K-12 to higher education. A part of their daily life relies on the social networking and cloud computing services for connecting with friends and taking advantage of online services for learning, with mobile technology becoming more common and accessible. The population of an activity in the cyber world will continue to grow tremendously. With the growth of the cyber world, the level of the cyber crime will continue to increase and poses a serious threat to online users now and in future. The limitation of the current law system, which vary between countries, create a real challenge in formulating any solution to combat the cyber crime. In addition, the protection of intellectual property rights such as raised privacy and copyright and freedom of expression issues are critically issues in the cyber world. The future challenge of how to protect the intellectual property from violation both in the real world and the cyber world requires further efforts in this research. Now, we will discuss the word computer software. Computer software is expensive to develop, but relatively easy to copy. Conditions that make it highly vulnerable to infringement of intellectual property rights. The issue of how to protect the computer software was first the Office of Technology Assessment has done a major study of the implication of the information related technologies for intellectual property rights. Intellectual property issues surrounding the new biotechnology have been the subject of a study done for the Organization for Economic Cooperation and Development in 1985 and were covered in an OTA in 1984. Assessment and subsequent report has been submitted in 1989. Acted on in the United States where protracted debate and many studies considered such alternatives as patents, copyrights and sui generis. Intellectual property rights proponents of the copyright protection for computer software argue that it is simply another form of writing brought about by the technical change. As were sound recording and motion pictures, proponents of the patent protections argue that the mental and financial effort required to produce software and the functional uses of the software more closely resembles inventive activity rather than artistic creation, and thus patents are the more appropriate analogy. Still others argue for a third approach, some form of sui generis protection. There is a unique form of protection for IPRs in the computer programs which mightly possibly have the characteristics of both copyright and patent law. In the United States, the debate resulted in the decision to protect computer software primarily under the copyright laws. In 1980, the Copyright Act of 1976 was amended explicitly to grant copyright protection for the software. The United States also has been encouraging other nations to protect computer software under copyright laws. Important question remains, however, about the adequacy of the copyright protection because of the fundamental limitations of the copyright, which protects the form of expression of an idea but not the idea itself. Perhaps for the reason as pointed by in this chapter 12 Pamela Samuelson, the precise nature of protection for computer program is still not certain in some countries, even though it may be covered under their copyright laws. Moreover, to complex matters even further, the US Patent and Trademark Office has been granting a growing number of patents for the computer programs. Now, we will discuss patents in a software. A patent is a 20 years exclusive monopoly on the right to make, use and sell a qualifying invention. This legal monopoly is considered a reward for the time and effort expended in creating the invention. In return, the invention must be described in detail to the patent office, which publish the information, thus increasing the amount of technological knowledge available to the public. To obtain a US patent, an inventor must apply to the patent office and demonstrate that the invention is new as compared to the prior technology, useful and non-obvious. An invention is non-obvious if it is more than a trivial obvious next step in the advance of technology. Software patents can be extremely powerful economic tools. They can protect features of a program that cannot be protected under copyright or trade secret law. For example, patents can be obtained for ideas, systems, methods, algorithms and functions embodied in a software product. Editing functions, users interface features, compiling techniques, operating system techniques, program algorithms, menu arrangements, display presentations or arrangements and program language translation methods. Since patent rights are exclusive, anyone making, using or selling the patented invention without the patent owner's authorization is guilty of the infringement. Penalties are stiff and include triple damages. Once a patent for an invention is granted, subsequent independent without access to the patented technology, development of the invention by another inventor is still considered infringement. A copyright. While a patent can protect the novel ideas embodied in the software program, a copyright cannot. Copyright protection extends to the particular form in which an idea is expressed. In the case of software, copyright law would protect the source and object code as well as certain unique original elements of the user interface. The owner of a copyright software program has certain exclusive rights with some exception. The right to copy software, create derivative or modified version of it and distributes copies to the public by license, sale or otherwise. Anyone exercising any of these exclusive rights without permission of the copyright owner is an infringer and subject to the liability for damages or statutory fines. As with the patents, the exclusive right afforded under the copyright law are intended to reward the creative and inventive efforts of the author of the copyright work. The exclusive right to control duplication protects the owner of the copyrighted software against the competition that would result from verbatim copying of the program's code. Copyright law also protects against indirect copying, such as unauthorized translation of the code into the different programming language. Copyright protection arises automatically upon the creation of an original work of authorship. There is no need to apply for a copyright or register the copyrighted work in order for the protection to exist. Generally, the duration of the copyright is the author's life plus 15 years. In the case of software created by an employee in the course of his or her employment, the resulting work made for hire would be protected by the copyright law for 75 years from publication. In contrast with the patents, independent development of a copyrighted work is a defense to an allegation of the copyright infringement. Imagine though how unlikely it would be for the same thousand of lines of the codes to be created independently by one not engaged in unauthorized copying. Unlike patents, copyright law affords no protection to the ideas underlying the programs. Ideas and concepts are fair game and competitors to the extent they are not protected by the patents or trade secrets. Now, we will discuss briefly what the trade secrets are. A trade secret is any formula, pattern, compound, device, process, tool or mechanism that is not generally known or discoverable by others, is maintained in secrecy by its owners and give its owner a competitive advantage because it is kept secret. The classic example of trade secret is the formula to Coca-Cola. A trade secret can theoretically last forever for as long as its owner uses reasonable efforts to keep it secret and someone else does not independently create or discover it. Many features of the software such as code and the ideas and concepts reflected in it can be protected as a trade secrets. This protection lasts as long as the protected element retain its trade secret status. Unlike patents, trade secret protection will not extend to the elements of the software that are readily ascertainable by the lawful means, such as reverse engineering or independent development. Trade secrets are not subject to being infringed as with the patents and the copyrights, but are subject to theft. Their legal status as a protectable intellectual property right will be upheld if the owner can prove the trade secret was not generally known and reasonable steps were taken to preserve its secrecy. Then maximizing the economic value of software asset critically depends on the understanding the nature of intellectual property rights involved and how best to use the available forms of legal protection to protect those rights, the role of intellectual property rights in the information and communication technology. The last 2 decades of the 20th century saw an intense debate on several intellectual property rights in the international fora, while developing countries intellectual property protection and technological development. In this concept, we will first discuss patent protection. Patent protection has a history of more than 500 years. While the patent system developed and evolved when the inventors were individual, it had to adapt itself to the situation of a corporate inventors who became prominent since the middle of the 20th century. It was only after the corporate inventor became prominent that a reasonably sound economic theory of patents could be developed in 1962, reasoned that knowledge being a public good, resource for its production will not be forthcoming and hence will have an adverse effect on welfare. To attract the investment into the knowledge production, the patent system, which gives a temporary legal monopoly to inventors, is necessary. It was contrary to the view of Schumpeter in 1971, who says that patents are not only unnecessary for encouraging inventions, but may also retard technological progress. In this Peter's evolutionary model, firms struggle to keep their market position by continuous innovations. For a firm, an innovation will itself create a temporary monopoly. During this period of monopoly, the inventing firm will make extra normal profits, but such profits will be eroded once other firms catches up by copying the innovation. Hence, a firm has to continuously innovate. The evolution of the inventor from individual inventor to a corporate inventor is very important. While for individual inventor, patents may be the only mechanism of the appropriation, for the corporate inventor, there are many more venues such as being incumbents in the market, being the first mover, as well as having the trademark recognition for his goods. There are inter-industry differences in the way they are dependent on the patent system for technological appropriation. This was clearly brought out by the Taylor and Sebastian in 1973, while for some industries such as pharmaceutical and fine chemicals, patent protection is very important. For some other industries such as in mechanical engineering industries, it is not. The reason for the dependence of the pharmaceutical industries or patent systems are the technology of production of drugs was easy to copy through reverse engineering and there are no entry barriers to the industry. The reasons for the technological changes not being dependent on the patent system in electronics, in which semiconductors, computers and telecommunication sectors fall, are the following. The rapid performance of the technological development, except for some radical and fundamental invention, most of the inventions have a life of a few years, much less than the full term of the patent. The minimum size of the break-even point is rising rapidly and making entry difficult. In standardized product, it is possible for entry. In niche products, there are economies of scale in production of these industries, which creates entry barriers. There are first movers advantages for the film, which brings the invention to the market. The other important factor is that the real prices of the products of these industries are falling over the time because of technological changes. Now, we will discuss the copyright protection. There are two areas in which copyright protection is crucial in ICT industries. These are computer software, including telecommunication software and internet. The very first reaction to protect software was through copyrights. Many countries, including India, amended their copyright laws to include computer software under copyright protection in 1984. One of the criticisms of the copyright protection for the software was that copyright did not protect the idea itself, but only a particular expression of the idea. While copyright protection for a mass market software seems to be quite effective, copyright protection for customized software is not important. The growth of the internet has put a lot of pressure on copyright protection. Many countries have strengthened their copyright protections in the digital. In the case of rapidly developing areas, patent protections may not be useful because invention quickly became outdated. As a result, the internet is not the same as it used to be in the earlier days. Most useful information which used to be freely available in the earlier. Then we will discuss some other issue, like first one is internet. The worldwide growth of the internet since 1995 has put a lot of pressure on intellectual property rights. Copyrights and neighboring rights saw an immediate impact on the internet on the rights they cover. Many areas of protections covered by the copyrights, literary works, audio, video, etc. came to be displayed and exchanged on the internet, causing loss to the right holders. While the copying of literary works seems to have subsided, there were some important cases involving distribution of musical works. The other area of immediate concern is the conflict between the trademarks and domain names. WIPO has evolved a mechanism to resolve these disputes. Then we will discuss computer software. Computer software is protected by the copyright in almost all the countries. Only the US and Japan give the patent protection. The experience in the US has been mixed. The main problem seems to be that the quality of patents issued in the software. The other problem is non-inclusion of non-patent prior art, which is very important in this field. Rapid change in technology makes patent protection unimportant. On the other hand, copyright protection seems to be inadequate. Indian companies are not active in seeking copyright protection in India or patent or copyright protection in the US. Piracy of packaged software in developing countries is because of high prices and discriminating pricing not being possible because of the leakages. Then we will discuss database protection. While databases which are original compilations are protected under copyright laws, the demand for the sui generis laws to protect unoriginal database is disturbing. The criteria seems to dilute the contribution required for obtaining protection. Denmark, Finland, Ireland, Mexico, Norway and Sweden have sui generis laws to protect unoriginal databases, while the EU has a directive to protect the databases since 1998. The US Congress is considering a database protection bill. The WIPO started a process for the database protection in 1996 and rejected a draft treaty and does not have any active proposal at the present time. So, in concluding remarks, I must say it's obvious that the management of IT and IPR is a multi-dimensional task and call for many different actions and strategies which need to be aligned with the national laws and international treaties and practices. It is no longer driven purely by a national perspective. IP and its associated rights are seriously influenced by the market needs, market response, cost involved in translating IP into commercial venture and so on. In other words, trades and commerce considerations are important in the management of IPR. Different forms of IPR demand different treatment. Handling, planning, strategies and engagement of person with different domain knowledge such as science, engineering, medicine, law, finance, marketing and economics. Each industry should evolve its own IP, policies, management style, strategies, etc. depending on its area of specialty. Pharmaceutical industry currently has an evolving IP strategy. Since there exists the increased possibility that some IPRs are invalid, antitrust law therefore needs to step in to ensure that invalid rights are not being unlawfully asserted to establish and maintain illegitimate and limited monopolies within the pharmaceutical industry. Still, many things remains to be resolved in this particular context. Thank you viewers for watching this program.